Order in the court. It's time for Understanding the Law Radio. Well, hi, and thanks for joining me for another episode of Understanding the Law Radio. I'm your host, Peter Lamont, and today we're going to be taking a look at whether or not you can trademark your superhero identity. Now, this is going to be very interesting for those of you who are superhero or comic book fans, but also for those of you who might own a business, because we are going to be connecting the dots between what we're talking about today, trademark, and how it will impact or affect or benefit your business. Now, if you think about superheroes, Batman, Iron Man, really any of the superheroes that we're familiar with, Aquaman, Wonder Woman, they have unique identities, right? Now, should they be able to trademark those identities to protect their intellectual property? Now, before we get into the question, I have to pose a question to you, and it's one that I think every kid growing up that was into superheroes, and maybe even some adults still ponder. If I had the choice of being any superhero in either the DC or Marvel universe, who would I be, right? And I'm going to put up a poll. I'll put up a poll on social media, maybe on Instagram, and then we'll read the results on Thursday. But I'm going to go out on a limb and say that it really is highly contested between those people who want to be Batman and those people who want to be Superman. And I just pose this analysis here. I think that Batman's awesome, right? But Batman, as we all know, has no superpowers. He's got money. But like all things that are tangible in this world, they are fleeting. So what happens when Bruce Wayne loses all his money? What is he left with? Some high-tech toys? He's got no superpowers. So I think, and I'm not trying to skew any of your opinions, but I think in my personal opinion, if I had to be one superhero, it would hands down be Superman. I can fly, I can see through things, I can use my laser vision to burn things, I am essentially indestructible, and I have not seen much kryptonite on planet Earth, so I think I might be okay. So I'm going to go with Superman. I'm going to put up a poll. You guys let me know who you would choose to be. All right, now, today's episode is going to set the stage for Thursday's show, where we're going to be swinging around to a new segment called Pop Culture Court. On Thursdays, we are going to be bringing you into the jury for a pop culture court analysis, and we're going to be looking at Spider-Man versus the Daily Bugle on Thursday. So you're all getting summoned for jury duty. You all have to attend on Thursday. But for today, we're going to be looking at this question of superheroes being able to trademark themselves. So let's start first with what is a trademark? And we have to look at the breakdown of what the legal definition of a trademark is. Now, a trademark is a legally registered symbol. It could be a word, it could be a phrase, but it must identify a distinguished product or service. Now, that's important, right? So we think of things like the Nike swoosh, the McDonald's golden arches. We think about let's get ready to rumble, the phrase. These things are uniquely distinct, and they are related to a product or a service. That's going to be important as we move forward through this. Now, in the superhero world, names like Batman and Superman and Iron Man, they're all registered and owned by their respective companies. So, for example, Batman is owned by DC and Hulk is owned by Marvel. So we're not talking about whether or not that superhero can trademark his name. We'll talk about that too. But for right now, what this means is that companies that hold the trademark for the Superman symbol, the S on his chest, although I thought I read somewhere that that's not an S, that is, I think I'm going to have to double check this, but I think that is like reference to Krypton, and it's not an S, but I grew up thinking it was an S, that sort of thing. So let me know about that. I think it has something to do with planet Krypton as opposed to an S. But anyway, those slogans and marks, like the symbol on Superman's chest and the name Superman, those are owned by Marvel or DC in this case, and that restricts you and me from going out, let's say, and opening up a Batman-themed restaurant or a Superman-themed restaurant without permission from the companies that own the trademarks, right? Like, have you ever listened to like an NFL broadcast and they say any use of the NFL symbol or logo or this transmission or blah, blah, blah is strictly prohibited and subject to, federal penalties, blah, blah. Well, that's because the NFL owns the trademark to the NFL symbol and logo, and we're not allowed to use that. And it's the same with Marvel and DC owning the superhero names and symbols and identifiers. So, you can't use them if you want to just open up a diner. And interestingly enough, and I've talked about this on the show before, there are so many places that are, even in like North Jersey area, that are using Batman and Superman and some of these other superheroes in their businesses or the symbols on their website, and they're not authorized to use them, right? Because I would imagine that it's a pretty penny to try to get Marvel or DC to authorize the commercial use of their trademark by, a small business. And I'm sure that some of these small businesses are just doing it. And it's interesting because at some point, does somebody go to DC or Marvel and say, hey, what's going on here? Is this restaurant actually, a Batman-themed restaurant? What is this? And then once they find out about it, because obviously it's very difficult for even a large company to patrol every small business that's opening up to see if they're infringing on the trademark. But who knows? It's an interesting thought. I'm sure that in your area, you've seen diners or restaurants or stores where maybe they've got superheroes theming or superhero theming on the walls or images or whatnot. But just an interesting thought. Now, let's say that you are a superhero. And let's say that you call yourself the Crimson Phantom. That's your name. You're the Crimson Phantom. I wouldn't choose that name because I would stumble over the word crimson too many times. So I couldn't call myself the Crimson Phantom, but you are. And you wear this crimson cape, and you've got a stylized logo on your chest, and you operate out of Metro Haven. That's your city, okay? Now, can you trademark your identity so that no upstart superhero wannabe can come in and say, hey, I am also the Crimson Phantom? Can you do that? It's a good question, right? Like, wouldn't Superman at some point be worried? Well, what if somebody comes in and all of a sudden they're Superman, like in Superman 3, when he splits into the good Superman and the bad Superman? Doesn't that cross his mind at some point? Or Batman? Look at that one Batman movie. I can't remember which one it was. I think it was the one with the guy from the vampire movies, where I think it was that one, where there's Batman imposters running around. Now, I mean, can he protect his trademark? Well, we're going to answer that. And the answer to that is, just like everything else in law, maybe, right? Law, as much as we like to think it's black and white, it is totally gray for the most part. And here's another example of that. The answer is maybe. So here's the catch. And this is what I was alluding to earlier when I was talking about business purpose and whatnot. Trademarks can only apply to commercial use. So if you're running around as the Crimson Phantom and you're fighting crime in Metro Haven, can you say, I'm going to trademark my name so that nobody else can take that? Well, no, because you're not involved in commerce. You might be preventing crime. You might be helping small businesses. You might be getting cats down from trees, but you're not engaged in a commercial activity. Now, I guess the interesting component to that would be, what if you were paid to do that? What if it was your job? What if you were, Superman 911, and when they call you, they have to pay you? Maybe there would be an exception to that. We'd have to explore that deeper. But on the surface, just as a superhero, as you being the Crimson Phantom, you're not going to be able to trademark that because you're not using it in commerce. Now, if you were to start selling T-shirts or licensing your Crimson Phantom name for movies or books or comic book series, well, now you're engaged in commercial activity, and maybe you'd be able to trademark your name at that time. You see, the distinction here is that when you're running around fighting crime, you are just the Crimson Phantom. That's who you are, right? But you're not engaged in any commercial activity. If you switch that around and now start selling merch out in the street corners, all right, well, now you might have a trademarkable brand. So different story there. Now, I don't see Superman or Bruce Wayne selling T-shirts on the street corner in their downtime. But if we look at characters like Tony Stark or Bruce Wayne, we see a lot of their tech, like the Iron Man tech, with Stark Industries on it. Now, Stark Industries is a business. They're operating in the commercial space. So that is trademarkable, right? And the same with Wayne Enterprises. That's a business. So anything that Batman or Bruce Wayne were to sort of stamp Wayne Enterprises, that would become trademarkable. And, you'd look at whether or not you put, Stark Enterprises on the Iron Man suit. Now, can he trademark or protect that Iron Man suit under the trademark? And I would argue that he could, because it's being, Stark itself is being used in commerce, and the suit is part of Stark Industries, which is trademark protected. And so in theory, in this roundabout way, the Iron Man suit could be protected under its affiliation with the trademark Stark Industries, okay? Let's say that Bruce Wayne has a new design for the Batmobile, and it says Wayne Enterprises because it's made by Wayne Enterprises. That might be something where he would be able to protect it via trademark. Okay, so does that make sense? Now, let's look at some real-life trademark superhero disputes. I'm not talking about Superman, arguing with Superboy or Supergirl. I'm talking about real-life cases. The first one I want to talk about is Superman and his superhero trademark dispute. Now, this is interesting because you'd think that the word superhero is public domain, meaning that anybody can use it. Superhero, right? But it's actually jointly owned by both Marvel and DC. They own the trademark to the phrase superhero. And it was first registered in 1979, and it applies to comics, magazines, and costumes. Now, this means that independent comic publishers and even businesses cannot use superhero in a title without the risk of potential legal action from DC or Marvel. Now, this is very interesting, and it's led to a lot of controversy in the comic book industry because so many people argue that superhero is just a generic term, but nobody's successfully challenged the jointly held trademark in court. So that's pretty interesting. I never realized when I was a kid what this whole impact of superhero and trademark was, but now as an adult, you look back at it and you're like, wow, there was a lot going on just, way above me at the time. And I was looking at, who the hero was. And here you've got Batman and Superman essentially sharing trademarks for the phrase superhero. Very interesting. All right, the other one, Captain Marvel name battle, Fawcett Comics versus DC and Marvel. The original Captain Marvel, who's now called Shazam. Funny movie, by the way, the first one. Not a big fan of the DC movies. I think that if you ask people Marvel or DC movies in the modern era, everyone's going to say Marvel. As a kid, the cartoons, I was more of a Super Friends, DC, Legion of Doom kind of guy, and Marvel was like okay. But now as an adult, I'm a Marvel guy. I don't know what to tell you. But anyway, getting back to Captain Marvel, now Shazam. It was created originally by Fawcett Comics in 1939. And DC sued Fawcett, claiming that Captain Marvel was essentially a copy of Superman. The case was National Comic Publications, Inc. versus Fawcett Publications. And this is 1951 decision. Now, Fawcett settled, and they stopped publishing Captain Marvel. DC later acquired the rights to the character. Meanwhile, Marvel Comics registered Captain Marvel as a trademark in 1967, and that's what forced DC to rename their character Shazam. So if you ever wondered why Shazam and Captain Marvel are confusing and why Shazam might look like Captain Marvel and you might think that he was, because I was confused about that, because I remember growing up and thinking that Captain Marvel and Shazam were essentially one and the same, but now you know what happened and how that came about. All right, the next one we're going to look at is the Batmobile case, DC Comics versus Mark Towell. So the Batmobile isn't just a car, right? It's considered a protected character, believe it or not, under copyright and trademark law. So the Batmobile itself is protected. So DC sued this guy, Mark Towell, who owned Gotham Garage, for selling Batmobile replicas without permission. This is a 2015 case. Towell argued that the Batmobile was a car design, not a character, but the court ruled that the Batmobile is a character with consistent traits and attributes and is instantly recognizable and has appeared in various iterations for decades. The Ninth Circuit ruled in favor of DC, and that means that any replica Batmobiles are unauthorized and violate copyright and trademark laws. Now, if you go back to what I said earlier in the podcast about these restaurants and diners and places that call themselves things like Gotham whatever or, Metropolis Diner, that essentially violates trademark law. Now, whether or not Marvel, DC ever learn about it, that's another story. But you can see how you've got a guy with the Gotham Garage selling replica Batmobiles and how that legal battle came to a head. So very interesting. The next one I want to talk about bridges the gap here between professional wrestling and Marvel. This is Hulk Hogan versus Marvel. Hulk Hogan, obviously the legendary WWF, WWE wrestler, originally used the name Hulk without Marvel's permission. Marvel actually owned the trademark for the Incredible Hulk, and in the early 1980s, they forced Hogan to sign a deal acknowledging Marvel's rights to the name. As part of the deal, Hogan had to pay Marvel a percentage of his earnings whenever he used the name Hulk. Eventually, though, WWE bought the rights from Marvel, this was in the early 2000s, so that Hogan wouldn't have to pay royalties anymore. Another interesting one. And the final one we're going to look at today is Ghost Rider copyright battle, Frederick versus Marvel. Gary Frederick, the creator of Ghost Rider in 1972, sued Marvel for ownership rights, and he argued that since he created the character, he should own the rights. Now, this is a 2013 court case. I remember looking at this when it was actually going on. The court ruled in favor of Marvel, saying that Frederick had signed a work-for-hire agreement and had no claim to the character. This is really an important case because it highlights how creators can lose control over their own creations. So we'll talk about work for hire on another episode, but if you are an independent contractor, an employee or whatnot, and you are creating a character for Marvel or DC, you don't own what you've created. The company does, and that's what happened here with Ghost Rider. So another interesting thing, and we'll look at that work for hire situation in a later episode. All right, now, what do all of these cases mean? Why do they matter? They all show how intellectual property is considered very valuable by these businesses. Now, they just happen to be comic book and superhero businesses, but the intellectual property component is very, very important. So much so that they'll sue to protect their rights. Now, what does that mean for you if you have your own superhero character? Well, if you don't trademark it or copyright it, you could very easily lose control of it. And if you use a superhero name that is somebody else's or somebody else owns it, you could be forced to rebrand or pay royalties, as we see with some of these cases, like the Hulk Hogan case, or with the Gotham Batmobile situation. And even famous people, another takeaway from this, like Hulk Hogan, they don't have power over the federal trademark protections. Even though he argued that it was his name and whatnot, Marvel still won. So it highlights essentially how important trademark and intellectual property rights are, and we're going to transition to what that means for your business in a moment. But just to sort of wrap this question up, can you trademark your superhero name? The answer is maybe, and now you see why. It really depends. You know, if you're in the stream of commerce, if you are a company that owns, like Stark Industries, you own the Iron Man suit, maybe there's protection, but it's not black and white. It's not clear cut. And hopefully now, through this discussion and the cases that we talked about, you can see why it's so difficult. All right. Now, let's swing around to businesses and creators. How do your trademarks apply to you? How do trademarks and trademark law apply to you as a business or a creator? So you're not a superhero, neither am I, but you're an entrepreneur, you're a business owner, you're a content creator, you have worked years, to build what you have. So how do trademarks apply to you? Well, in the same way that Marvel and DC wanted to protect their superheroes, their brands, you, as a content creator or business owner, you have to protect your own brand and creations as well. So if you're launching a new product or you have an existing business name or a logo and you don't have it trademarked, you need to start thinking about getting it trademarked. And in making that analysis, you should look at, number one, is it unique, right? Because a trademark must be distinctive. You can't trademark a generic name like, I don't know, let's stick with superheroes. If you want to be Fast Guy, you're not going to be able to trademark Fast Guy because it's not distinctive. It's merely descriptive. Fast Guy is not a trademarkable phrase, okay? Now, so that's number one. You've got to make sure it's unique and distinctive. Number two, are you using it in commerce? That's a very critical question because if you're not using it in commerce, you're not going to be able to trademark it. They only apply trademarks when you are linking it to a business or a service, a product, a goods, whatnot. But if you don't have it in commercial use, you're not going to be able to trademark it. And then finally, registering that trademark. A lot of people think that, especially in the copyright realm, and I know we're talking primarily about trademarks here, but a lot of people think, well, if I write it, then it's copyright protected because I wrote it. And there's some truth to that. But if you want to take legal action and you want to have the protections of being able to say to somebody, you're infringing on my trademark and here's my registration number, you've got to make sure that you register your trademark or copyright with the USPTO. That's very, very important. So if you're looking to prevent people from infringing on your brand or stealing your business's identity or logo, then you really need to think about trademarking. Trademarking is obviously something that you can go to a lawyer for, and they can help you through the process. It's also something, quite frankly, you could try to do yourself. The only thing I caution about there is that you pay a fee, and it's a non-refundable fee. So if for whatever reason you screw up the application or you select the wrong class or there's an office action that's initiated by the examining attorney, you could lose your initial payment and you might have to refile or you could be barred from refiling depending upon the outcome of the office action. So always a good idea to have an attorney assist you, Can you do it yourself? Yeah, if you take your time and you really learn about the process, it's doable. It's just complicated. So it depends on how much money you want to spend and how serious you are about protecting your business. All right, so let's wrap up today's episode. Going back to the question, can you trademark your superhero identity? We talked about that. We said maybe, unless it's in commerce, and then the answer would be yes. So if Spider-Man were a real person, could he trademark the name Spider-Man? What's the answer to that? Probably not, unless he was using it as part of a business. Now, of course, Marvel can trademark it because it's a character in their business and they own the rights. All right, well, hopefully that answers this very, very intriguing question. I think it's intriguing, and I think that connecting the dots between this superhero analysis and your business, I think it's very, very important, because you can kind of see it illustrated, pun intended, in a different way by looking at how comic book companies like Marvel and DC protect their intellectual property. All right, now that brings us to this coming Thursday. We're going to be doing on Thursdays Pop Culture Court. I told you at the beginning of the episode, you've all been summoned. You are all receiving jury duty notices so that you must attend Thursday's Pop Culture Court analysis. You're going to be brought into the virtual courtroom, if you will, and we're going to be looking at, can Peter Parker sue the Daily Bugle for defamation? We'll explain that topic. Does Jonah Jameson have the right to call him a menace? Could Spider-Man win the lawsuit? Well, we're going to look at that on Thursday. But we're going to bring Spider-Man into the courtroom, and hopefully you come with him and examine this new Thursday segment called Pop Culture Court here on UTL Radio, Understanding the Law Radio. I appreciate you listening, downloading the episode. Please make sure you share it. Make sure you tell people about the podcast. We've been doing this for a long time, and when you let colleagues and friends know about the podcast or the episode, it certainly helps spread the word and gets more people to the podcast, so that some of this information, which hopefully is valuable to you, can be shared and spread around. Well, that's going to do it. Thanks for joining me. I will see you Thursday on Pop Culture Court. Thanks for listening to Understanding the Law Radio. If you haven't done so already, make sure that you subscribe to the podcast. We're available anywhere that you listen to your podcasts, including Amazon, Apple Music, Spotify, iHeartRadio, and many more. Also, don't forget to check us out online on Facebook, Twitter, and Instagram. Thanks again. See you next time.